Hello everyone, my name is Kelly and I'm here to provide a refutation speech to Armando's claim of facts. Advocate Armando's main claim was affirmative action detrimentally affects those who it's supposed to serve. The advocate then sets up secondary claims in the structure of a chain argument. The secondary claims were 1. Reverse discrimination, 2. Affirmative action lowers expectations, and 3. Affirmative action leads to failure. Since this is a chain argument that interlinks each subject as a result to the previous, I'm going to be focusing primarily on the advocate's first supporting claim. Once again, the first supporting claim was reverse discrimination. The advocate provides 2 examples to support this topic. The first example was a case in Michigan describing the unacceptance of qualified Asian students due to affirmative action. I, however, challenge this evidence since this data was gathered 14 years ago. In 1997, the poll was, this 1997 poll is outdated and dismisses any relevance to the current acceptance rate and standards of the University of Michigan Medical School. I'm also going to provide a counterclaim that presents new and current evidence provided by Michigan University. That will be my that school will serve as my example. I'm going to provide, my counterclaim is that to the argument support is that new laws prohibiting affirmative action have restructured and augmented the criteria used for accepting students to college. I will also be using the same example, as I said, the School of Michigan. My 2 supporting claims are affirmative action has been banned from many public colleges in multiple states. There are many other factors, and number 2 is there are many other factors to consider before accepting applicants. Now for my first supporting claim, that affirmative action has been banned from many public colleges in multiple states. The example I'll use once again, is Michigan, and stated by American Medical News, Michigan state voters passed a law to ban affirmative action in the year 2006, which is 9 years later than this poll was taken. Written by Myral Crosendale, this article shows that the state of Michigan voted and passed a law to ban affirmative action in education altogether. Now for my second supporting claim, there are other factors that colleges consider before accepting applicants. According to the same college, some of these factors include classification of tuition, advanced standing, transfer students, the university's budget, limited funding, and the lack of space. These criteria were referenced from the Michigan Medical School's admission personnel. In closing this counterclaim, I'd like to, the evidence I just explained shows that this case that was given as an example is, in Armando's claim, is inapplicable to the advocate's claim of affirmative action. Returning to the advocate's first supporting claim in his speech, which again was reverse discrimination, I would now like to reference more of his supporting evidence. Another example presented to support reverse discrimination was the example case of minority firefighters that are favored for unfair promotions. The advocate did not provide any evidence or source to back this example. After researching this myself, I found that the facts presented by the advocate were falsely represented. The example he described was supposed to demonstrate how qualification tests for promotions were eliminated because officials said it left too few minorities qualified. This statement was true, however, Armando then states that his argument that promotions were given to these minorities despite test qualifications and results. This is a fabrication of the truth ruling of the Supreme Court case. I deny the advocate's evidence because he states that these promotions were given when in actuality no promotions were given at all. Stated by the U.S. Supreme Court on June 29, 2009, 1 Latino and no African American firefighters qualified for promotions based on the exam. The city decided not to certify the results and issued no promotions. This case serves not just no support to the claim and is relevant because it falsifies the outcome of the true ruling. This in turn diminishes the credibility of the advocate and his argument by providing false information to his supporting claim. I'll not be refuting anything from the advocate's secondary claim that affirmative action lowers expectations because no evidence or specific examples were covered in his speech. The third and final supporting claim, the advocate declared that affirmative action leads to failure. However, the support consisted of multiple percentages that were listed in a timely manner, and there was lack of clarification as to what these numbers actually meant. In closing, the chain of argument that the advocate initially set up was not as effective as it should have been, since he skipped any kind of evidence and reasoning for the second supporting claim. This caused a gap in the argument's chain and flow. I'd like to thank the advocate, though, for educating us on the matter and for his efforts to prove his argument. Thank you for your time.
All right, you labeled the main claims. The argument seems to be predicated on the notion that it's a chain of arguments, and I'm not exactly sure that you explain how it is a chain. In other words, if there is no reverse discrimination, then there can't be any lowered expectations or any failure. So I guess that's the way that you're reading that first point and suggesting that there is, in fact, no such thing as the reverse discrimination that the advocate's talking about. That, I think, is the way you want to phrase that argument. I thought you got a little convoluted in presenting some of your counterclaim because you are over-organizing it, and so some of the material gets a little lost in the fray. It basically comes down to an argument about whether or not the case that the advocate used from the University of Michigan is still viable and applicable in making this particular claim. And you have very good evidence that suggests that the case is in fact largely moot, and you don't really discuss whether or not it was accurate at the time, but you do discuss whether or not it is applicable now. And if it's not applicable now, then your inference is that we can't really reach this conclusion about what's going on right now. And I thought that that was pretty well explained. Like I said, it just got a little over organized there, and I think you need to have a simpler way of explaining it. On the later part on that, when you had the factual data about the Michigan rules, there's some discussion about some other factors that are going on, and other issues that they use in making the decision about who to admit. But I'm not sure how that's going to apply to the argument that you're talking about. Basically, it comes down to you're making an inference that the advocate's evidence is inapplicable because it's outdated and because the rules have changed on this particular situation. Now, on the second example that you talk about concerning the firefighters, basically you say he's a liar. And I think you want to be a little bit careful about describing it that way. I think that he maybe has presented information that is either non-specific to a particular case, or if it is specific to this particular case, reaches a conclusion that's not validated by the way the facts came out. And then talk about the court ruling. You've got a good quote there that talks about what happened in this particular situation, and I take it that the court upheld the decision of the local municipality not to offer promotions to anybody because of the scores. And if that's the case, then there isn't an example that the advocate can use to support that particular point. Then you kind of talk about point 2 and point 3 in this sort of a sketchy way. If you're not really going to say anything on those particular points, I think it would make more sense to just come back and explain why, if you have sufficiently answered the first point, the second and the third points don't matter anymore. And that's where you need to make a little bit more defense of this notion that the advocate's argument is a chain dependent upon that first step. Excuse me.